Hi, Attorney Steve Vondran, the business and real estate lawyer. We are back in this video talking about the CCP 998 offer to compromise in California in litigation cases. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, let's back it up here. Okay, so we're talking in this video about the CCP 998 offer. This comes from the code section. California Code of Civil Procedure is what the CCP stands for. Section 998 is your relevant section here. And this is something that comes up in almost every litigation case and can also pop up in arbitration. But it comes up in almost every case, and it's, you know, when you think about it, when you're in litigation, you can send offers to settle your case at any time, a confidential offer to settle, okay? But what the CCP 998 does, this is different from your typical settlement offer. The CCP 998 offer is a cost shifting statute, okay? It's designed to facilitate settlement, and it basically comes down to you sending a CCP 998 offer, the plaintiff or the defendant, to the other party, and it results in you saying, here's what I think you're going to be paying at the end of the day. We will not obtain less than, let's just take a number, $500,000. Say you're in a financial elder abuse case and you say, I know for a fact I'm going to get $500,000. You took my equity in my property. It's $1 million equity. I know for a fact I'm going to be able to prove at trial at least $500,000 in damages. So what you can do as a plaintiff in that case is you can send over a CCP 998 offer telling the other party, we want $500,000, okay? If I don't get my $500,000, you're going to pay my costs. You're going to pay my costs of filing, my fees. You might have to pay my expert witness fees and other fees that arise in the case. You may have to pay interest as well, okay? So now usually this is not going to cover your attorney fees, so bear that in mind. It's not going to cover your attorney fees. Attorney fees will be recoverable only if you have a statute or a contract that allows you to recover attorney fees. The nice thing in California financial elder abuse cases is the statute does provide for attorney fees. So in this case, if the defendant doesn't pay your $500,000, they could end up paying costs, expert witness, interest, and your attorney fees. So it can be substantial. So these are CCP 998 offers are known as a settlement offer with some teeth and some bite to it. Okay, so these are a good tool in the litigator's toolbox, the 998. Now I drew up here basically how it works. As you know, the complaint's filed by one party. This can also be an arbitration. Okay, so if an arbitration is filed by one party against another, the CCP 998 offers in California can be used. Then you have usually your answer, your motion to dismiss, your demur, depends which court you're in. And then the parties get into discovery, and that's discoveries where you find out and you prove your facts, you prove the other party's facts aren't true, you get your discovery, you get your evidence, you take your depositions, you figure out what's going on in your case. Now this, one question is, well, when can you file a 998 offer? Well, basically any time prior to 10 days before trial. So you have this great leeway from the time the complaint is filed all the way up to trial. So you have plenty of time to get this in. A good time may be when you have established the facts that you're trying to prove in discovery. You've got the sworn testimony, you've got the depositions, you've subpoenaed the documents you need, you've got your request for production of documents, your answers to interrogatories, your answers to requests for admissions, and you say, you know what? I got the evidence. I have got the evidence against these guys. That may be the good time to send off your 998 offer to your other party, okay? So, but keep in mind you can do it up till 10 days prior to trial, so use it when it makes sense, okay? So here we have just a rendition of our plaintiff and our defendant. Keep in mind either party can do it. In a case, both are normally going to do it, because if the defendant says you're only going to get this, and you say, I will, they say you're only going to get $250, and you say, no, I know for sure I'm getting $500,000 for sure, then they may send you a $250 offer. If you don't beat the 998, if you don't get more than $250, now you may be paying their fees and their expert witness fees. and interest and those kinds of things, okay? So you bear that in mind. It's a tool for both parties in litigation or in arbitration, anytime up to 10 days, okay? So that takes care of that. Now, I'm going to come over here and switch colors with you real quick. I'm just going to we've hit this. Let's talk about we have a little list of takeaways here, some little nitty-gritties about 998 offers, things you might not find online. Okay, so if you need more information, we got it here at 998offer.com. So go check that out if you need a little more in-depth information. But again, either party can do it. If you have multiple defendants, if as a plaintiff you're suing 3 different defendants, okay, you got a real estate broker and you got an escrow company and you have some foreclosure trustee or something. You got 3 different parties, okay? You don't have to send the offer to all 3. You don't have to send a global 998. You can pick and choose what you're going to send to each party. Each party may have different levels of liability. Okay, so you can pick and choose on multiple defendants. Okay, how long is the offer open? By statute, when you make a 998 offer, it's going to be open for 30 days. 30 days. Okay, so typically the other party's going to get it. They're going to review it. They're going to discuss with their clients, and they're going to decide: is this really worth 500? Is this maybe worth settling now, or should we keep going forward, figure this out later, or make our own 99.98 back lower? Should we counter? Should we settle? So again, it's a tool to facilitate settlement, so use it wisely. It is revocable. So, for example, you may send an offer for 500, and you're 15 days into the offer. They're open for 30, and you get a piece of evidence mailed to you from one of the parties, and you're sifting through it, and you go, you know what, we have clear liability now. These documents establish clear liability. You know what, this 500 is too low. It's got to be $1 million. It's got to be $1 million, because we now have that solid smoking gun, that written evidence that we need. And so you may come back and revoke your 998. You can revoke your 998, so keep that in mind. Again, these 998 offers need to be in writing to be enforceable as such. Don't do it over the phone. Don't say I called them and we had it all worked out. No. Put it in writing. If you're going to revoke it, put it in writing. Okay? Ascertainable amount. So when you're making these offers, you want to have a number like $1 million. You don't want to start, and you want to refer to things that are involved in the litigation. You don't want to say, you know, we'll settle this dispute and you have to mow my grass for the next 5 years. You know, something like that. You want to be talking about, to settle our facts, our case, it's $1 million. Something that the judge can look at and go, yes, yes, I see. It's $1 million. They made you that offer. They got $1.2 million at trial. You lose. You didn't beat your 998. You pay. Okay, that's how it works. So make it an ascertainable amount. Not really. You really want to have monetary remedies. There are ways to do some non-monetary, but that's where you're going to need to consult with your counsel. Okay. Made in good faith. They must be made in good faith to be enforceable with a reasonable belief that the other party may accept. There's some case law on that. Acceptance is just like your real estate contracts. I make an offer for $1 million, you got to accept for $1 million. If you say $1 million and you throw in, 25 heads of cattle, then you don't have an unequivocal acceptance. What you actually have is a counter offer. Okay, so acceptances must be unequivocal and basically a mirror image is what you're looking for. Okay, if the case gets settled, the parties agree, then and only then does the 998 offer get filed. You end up dismissing the case with the court. So you do not file the 998 offers with the court. Okay, but it will effectuate your settlement. Again, cut off 10 days prior to trial, and again, it applies in arbitration and litigation. So that's the quick and dirty 998 offer. If you need more information, go to 998offer.com. Make sure you subscribe to our videos. Click on that V so you keep the information coming to you, the free legal information, general information from Attorney Steve. Okay? So again, we look forward to helping you. If you have questions with litigation, arbitration, business, real estate, insurance, personal injury, intellectual property disputes, give us a call. We're happy to help and fight for your rights. Thanks again, and feel free to share this video on your social media networks. We'll talk to you again.